Good morning. Good morning, everyone from Brazil. I'm part of Friends of the Earth International, and I want to thank all Homa's team for organizing this 8th international treaty. It's a reason of happiness to me to open the seminar with our proposal. Recently, we had the 7th session of negotiations for the binding treaty. As Adoracion said, we could not open this seminar on businesses and human rights in a different way, other than speaking of the proposal that for which we have been struggling in the UN, but as Gonzalo reinforced, in other arenas also, in struggles inspired by the binding treaty. Now that our debate aims at analyzing perspectives and challenges of this agenda for the binding treaty, which is an agenda that Homa has been fighting for many years. For those who do not know the process, it's an opportunity to get engaged in the political and juridical construction of this process, which is something that we are constantly reinforcing, this importance of seeing the treaty as a political and juridical process. For those who are already in this struggle, in this dispute for making the binding treaty not an instrument, that it's not empty, that it's not like a blank paper, but something that will bring justice, bring fair treatment for people and communities that have been affected by transnational companies' violations of human rights. Those who have been in this struggle, for those who are in this struggle for a long time, is a moment to go deeper, to exchange experiences in this recently and the 7th session of negotiations. So I want to especially acknowledge Roma. Gonzalo, he said that in the last session, specifically, we were watching the big team, a large team of people that were with us face to face. It was a hybrid session, this last session that we were. So most of our brothers and sisters could not be present, but they participated virtually. But there was a delegation of a little bit more than 20 people that were there with us, and then he was sitting there, watching the team working. I am a biologist. I'm not a lawyer, but I never sit back and watch. I was always constantly trying to ask questions and get everything that I could from this wonderful team. So it's a wonderful to see a skilled team made of academics and with this qualification for capacity building that is working hand in hand with our team at the service of this wonderful work. This is exactly what we need on the side of organizations and movements in the struggle and in the advocacy of human rights.
So once more, thank you. And I also want to say that I mean, I'm always learning a lot of legal terms, especially now working towards the treaty is really difficult because it's a legal discussion. So we're always a little bit behind in trying to expand the discussion to other people, to those people who don't have so much legal knowledge. So there's something else that we're doing together with OMA and Transnational Institute, that Gonzalo is part of, OMAB, the movement of affected by dams, and Friends of the Earth in Brazil. We have a popular notebook that talks about a binding treaty and the need of a legal framework in Brazil to end impunity, corporate impunity. So I'm just sharing this with you for you to know. For this discussion, for us to continue with the debate, we have comrades that reflect the seventh session with women. We actually had a feminist analysis with women. It wasn't only OMA with women, but also most of the leaders from movements, from organizations were women. The states that were more aligned with the global campaign to dismantling corporate power were led by women. So I'm really happy that we had this group of women who present the feminist perspective for this fight against transnational companies. Women are not only more affected by the companies, but we also stand up for our rights. I'm going to introduce our comrades. I'm going to introduce the format of the debate. I'm going to turn it over to each comrade. With a, each comrade will explain where they operate, and then we have debate. You can ask questions or you can make a comment. There is the QA box for questions and comments, or you can also raise your hand, and we turn it over to you. You ask the question, then we're gonna have a round of responses. Okay. Today we have with us Chinamazu from OMA, Manja Bayani from Indigenous People Rights International, Fernanda Copan, I think, maybe I mispronounced the name, from the UN Working Group of Human Rights in Business from the Caribbean, and Erica Mendes from Environmental Justice, friend of ours, Mozambique, and the coordinator of Economic Justice and Resistance to Neoliberalism from friend of ours, Africa. So the first one that we'll talk will be Fernanda from the UN Working Group on Human Rights and Businesses. She's an expert in human rights and business and dedicates to human rights, gender justice for over 20 years. She's been in this position since 2013, and she's the chair of a desk. She's the treasurer of Earth Rights International and also part of the foundation for the International Award Human Rights and Businesses. She's a professor at Simone de Beauvoir Institute in Mexico, and she's been invited to be part of this working group. She's a sociologist with a specialization in Latin American studies. So, Fernanda, I'm really excited to have you. And I turn it over to you for you to make the first explanation about the challenges and perspectives in this agenda. Thank you, Leticia. Good morning. Good afternoon. I'm going to speak as Spanish, but I just wanted to say a few words in Portuguese because we are in Brazil virtually, but our heart is in Brazil. Good afternoon. Good morning, everybody. I'm calling from Geneva, where I just started in the UN Working Group on Human Rights and Business representing Latin America and the Caribbean. I've just started my term on November 1st, so I'm the new one, and we know one another from the struggles for human rights in businesses, and especially social movements where I started. So I hope that that you have an ally in this working group, and whatever we were working on before that, I'll keep working on as much as possible in this new space. This working group was created in 2011, building on the human rights business group. I think most of you know in 2014, the UN Human Rights Council approved a resolution that started the negotiations for a binding treaty, as we call today. And since then, we have had a lot of work, especially by the civil society, to drive discussions and priorities in the agenda, and also to put pressure on states to get involved in the works of negotiating proactively, and that they don't hide behind other possibilities of actions of voluntary agenda. UN principles are a soft legal agenda, but with the working group, we have promoted something that we call a combination, an intelligence, a smart combination of measures. And by having so many activities, as Alessio has said, there are other mechanisms to guarantee access to justice against human rights violations by companies, and also come up with public policies, legal frameworks, and better tools such as a binding treaty would be part of this smart combination that we're working for. So, from my perspective, I'm not the only one in the working group that think like this. The efforts to come up with the binding treaty is fundamental to guarantee the protection of rights, access to medication, prevention, and also that we actually deconstruct the corporate impunity that we have witnessed for so many decades. Of course, I also believe that the treaty is not the only tool that we need and that we have, although it is crucial. So we have promoted a smart combination of measures, and I believe that this approach, in terms of corporate human rights violation, has to be structural, systematic, with a combination of regulations, policies, and practices. So I believe in this pack. We also have the treaty and the negotiations that we have been having for over seven sessions. So I think our colleagues have already said this in the opening. I want to share with you that on October 19th, some days before, I we had the seventh session of negotiations by this intergovernmental group that has the states negotiating this in this tool. The working group, together with other special groups, you gotta remember that the UN working group is part of a pack of mechanisms that depend on the UN Human Rights Council, which is called the special procedures. We have expert groups just like this one. We have independent experts and also the special rapporteurs. So, in a public communication, a joint one with the working group, we have extreme poverty report, human rights and environment reports, and toxic substance handling, and also the one of using mercenaries. They made this public communication calling the states to participate actively and constructively in negotiations in the seventh session of this working group, so that we could advance towards the binding treaty. In this communique, it we had as crucial preventing abuse, and they talk about three topics: due diligence, as Adoracion has talked about. So we have to have compulsory processes of human rights due diligence. We have to guarantee the access to medications and appropriate repair. And I also talked about the protection of people who fight for human rights. So these are the 3 points to prevent abuse and to guarantee access to medication and justice. We talked about the wording. The sum of the wordings already in the guiding principles. So there's a lot that we have built, led by Ecuador, has to do with building on guiding principles and going deeper into them and making them compulsory. And we also had this communique. And as I said before, they also talk about the smart combination. Of course, we talk about the relevance of this kind of tool with the end of addressing the asymmetries created by the free trade agreement or investment agreements that give rights or facilities or easiness to the companies, but that don't set obligations as to human rights, and this creates asymmetry between the trade, financial, investment structure, and which is the companies, and the human rights obligations. So this kind of treaty would try and bridge this gap of asymmetry that is created by the free trade agreements. And I think this is really important. So from civil society, we have actually been discussing this in negotiations to to come up with a binding treaty. Of course, we need to have a level field internationally speaking with the same rules through an international binding treaty would be crucial, which was highlighted in this communique. And the communique, I mean, I'm saying this because I think it is important that it is the first time that the working group jointly with other procedures have made a statement of this kind of before the negotiations for the treaty, and they set the support for the process. And I think this is crucial because at the end of the day, at the end of this communication, they recognize the limitations that they have had in terms of guiding principles. We have come a long way in the last 10 years, but the victims of corporate abuse, they're still fighting to have access to remediation, to have the to be able to defend human rights. So they call for a change, and the binding treaty would be an opportunity for this change. I'm really happy to be part of the working group right now in these conditions because I believe that there is an opportunity to push compulsory mandatory measures, not only for the treaty, but especially for the treaty. We are many people right now in the working group that are published, that are in favor of creating this binding treaty. And I think this is a great opportunity that we can tap into to use the working group as one of the possible platforms to drive negotiations in favor of the treaty. Of course, the feminist perspective is key. It's part of the agenda that I contributed to the working group. I'm one of the founding members of the Feminists for the Treaty, which is a collective that has grown over the years. We have created a small group in 2019 in Geneva. And of course, the agenda, the gender agenda, the feminist agenda, and all the work for human rights and business in the group will be crucial for me. And for the treaty, I believe this is a fundamental contribution that we have had from the civil society, historically speaking. Well, and Leticia, I would leave at that. This is my first intervention for the first round to turn it over to our comrades. But I want to share the stance of the working group, my personal stance. I think many of you know, but I just ratify my stance. And you count on an ally in the working group since November 1st, and I hope that we can work together so that we can protect the human rights against the international company, the transnational companies' activities. Thank you. Thank you, Fernanda. It's really good to hear you and to know that we have an ally in the working group at the UN. It's really crucial for us to have this coordinated work in an alliance. As our next guest is Erica Mintz. I think she's turning on her camera now. She's from Environmental Justice, Friend of the Earth, Mozambique. She's a friend. She coordinates the social justice and resistance to neoliberalism of FOEI in Africa. She's been working with on the Biden Treaty since the beginning. And she's going to talk about the regional perspective from Africa and how this work is coordinated with the African states. Erica, over to you. And I thank you for being with us. I know that it's complicated for you there because you are defending those affected by Valley right now in Africa. But it's really great to hear from you and to learn from the African perspective. Thank you, Leticia. And I'd like to quickly thank Oma because they have been fundamental partners in this struggle, and us in Mozambique don't have a lot of materials in Portuguese about this topic, so we have used OMA's analysis and contributions around biting treaty and corporate impunity. So it's really great to be with you once more with OMA. So, first of all, I have to say that we have this context that shows why we need this biting treatment. I just left the 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 courtroom in Teta, Mozambique, for those who keep up with Valley crimes. This is the cradle of Valley in Mozambique. And right now we have four citizens from neighborhoods near the mine that have been in prison since Saturday, illegally held in prison. They are charged with abusing the communities because they had a meeting with the families that have been affected by the explosions in the mines. It's dozens of houses that are actually some came down, and they have organized to fight for indemnization, for compensation for the damages. So in this meeting, they have decided that they would donate something that's equivalent to 10 cents of reais, 15 cents of reais within their possibilities so that full representatives of the community could go to the meetings.
Could then print the documents, could um, go to different places. So they were accused of violations in an anonymous denunciation, and this is one of the cases that have been happening here. We are constantly hearing that Vale is under the skirts of the government. This is what people say here. We know that transnational companies, big companies as Vale, have the capacity and the power to bribe people, decision makers, government officials at all levels, and from the judiciary branch to law enforcement agencies, the attorney's office. So unfortunately, I cannot remain in the conversation till the end, but I will leave my contact info if you need to talk to me. So, or wish to talk to me. I want to reinforce the importance of the binding treaty to the African region. Here we have the case of Mozambique. It's not different from many other countries in Africa and unfortunately other regions, but we have a context of very weak democracies due to several decades or even centuries of colonization, of wars, freedom wars or civil wars, and neocolonialism. So we have co-optable governments, co-optable by the interests of the big capital. Vale is one of the examples, but we have other examples in the country and in the province. So this is the situation that we have been living here, that results from a process that have been unfolding in two different fronts. In one side, we have the external aid agencies, international institutions such as the IMF, the World Bank that offer aid, loans, in exchange for neoliberal policies and a greater flexibilization of our own legislations or any other type of negotiations that could stop the power of transnational companies, or as they say, make investments more difficult or make the country less attractive. On the other hand, the second front is the second is the transnational companies that come with all of their power, their structure to enjoy this environment of deregulation and impunity that is created by these actors in the front line of financial institutions. What we see here is an example. In the north of Mozambique, we have a situation of war, also fed by the interests of natural gas companies such as Total, Eni, and Agar. So this is the context that we have here, where we have an impunity and a lack of possibility of having access to justice through national systems. At the same time, more and more, we see that our governments have also see the loss of their sovereignty and the weak power that they have in face of these corporations. Unfortunately, the governments that have been able to fight against that are still an exception, but in progressive governments, we see that they find a lot of difficulties in this struggle. Some companies are reforming or ending all free trade agreements or bilateral agreements with ISDS covenant. So there are some initiatives still, but they are not enough. This context is extremely important for our fight in the UN to advance towards a binding treatment. It's not by coincidence that this process started the initiative of two governments in the Global South, in South Africa, and have been also driven by other states in the Global South. The African continent has been one of the main drivers in this process, both as the African continent representing 54 countries, but at the individual level, several companies have been active, such as the case of Namibia, South Africa, Algeria, Ethiopia, Cameroon, and others. For us, it's important that in the end we find a binding treaty that is strong and effective. it's not enough to have just any international treaty or any other treaty, because we've seen many other processes, especially what we have, the voluntary press processes of guiding principles that cannot stop impunity. So for the African context, to have a strong and effective treaty means that some fundamental elements should be included. These elements are part of the struggle that we have been fighting for our main demands at the level of African movements, and also Friends of the Earth International, to demobilize the corporate power. Some of these elements include, for example, the scope of application of the treaty. From the beginning, we have been fighting for to expand the scope, that it means that we must focus on the transnational character of these corporations, because these are the companies that are benefited from this international gap that allows them in different jurisdictions where they fight to escape completely their responsibilities at the national level. So we have been asking that these companies are not applicable to all companies, such as small and mid-sized companies that already have their legislation in place to regulate their activities. And on the other hand, we must be really clear on the scope of application, because when we say that we must focus on transnational companies, this must necessarily mean that all the stakeholders in the global chain should be involved. This is what we call solidar accountability of all actors in the chain. This must include subsidiaries, branches, outsourced companies, subcontractors, and even funding parties, payers. From the moment that there is some connection among the companies, or that they are somehow benefited from activities that may contribute for violation of human rights, then naturally all of these actors must be accountable. And this should be proportional to the level of control of power, meaning that parent companies, sometimes headquartered in the global north, oftentimes headquartered on global north, should be accountable for the responsibility in changing the practice in the value chain. So at the same time, the treaty should must have the scope of action with transnational companies, but also at the same time including all different actors, as long as they have some kind of transnational activities or that they are inserted in the context of transnational companies. This was a very interesting debate that we had in the last session. The last section of October, we have the seventh session of negotiation. It was really interesting to see that the debate around the scope of application was strengthened again. This was an element that ended up being diluted and lost in the last two drafts of the treaty. So African companies specifically have been defending that the scope of application should be focused on transnational companies. Otherwise, the treaty would be virtually impossible to enforce. So we believe that in this aspect, the seventh session was positive because it brought this debate back and we strengthened again the focus on transnational companies. Of course, that this is very controversial. Therefore, several countries in the global north and companies such as China, for example, have been fighting actively for a treaty that makes sure that all the companies are covered by the treaty. Second important element that I want to bring is the need that this treaty to include legal binding obligations for transnational companies. If the treaty is just a way of re-emphasizing human rights principles for states, considering that the states already have this kind of principle, this treaty will not take the step forward that we We hope it does in a way that making sure that in so many cases where our governments, our states are not capable or are not willing or cannot regulate these transnational companies, then we make sure that the affected people can still have access to justice. And this must mean that direct legal obligations for transnational companies must be very clearly outlined in the text of the treaty. This has been debated along the last sessions, and in the last draft, we have included the word obligations in the preamble of the text of the treaty, obligations of transnational companies. Although this is positive, it's still not enough because it delegates to the states, to national states, the definition of what are these obligations. So what we want to see is that these obligations are clearly established, listed, and defined in the other articles of the treaty to make sure that there are not gaps and that we do not go back to face the obstacles of national governments not defining what are these obligations. This narrative around these direct obligations have advanced in this last session, especially defended by some African states and other states of the Global South, which re-emphasized very clearly that this treaty must enforce these obligations. So we hope to take a step forward instead of simply listing the obligations of states have with human rights. I think this is very positive, very much related to this hard effort that of different social movements and organizations have been carrying out along recent years to demanding that these direct legal obligations are included in the text of the treaty. Another important point for us in the region with which we have been working is the implementation of the text of the treaty. So I'm here and we are here in the first hand to see the inability of our national courts to deal with questions of the corporate power, the violation of human rights caused by transnational companies. Therefore, it is essential that the treaty include implementation mechanisms. That's why we proposed an international court for transnational companies. Friends of the Earth Africa proposed a concrete proposal how this treaty could work. And at the level of the global campaign, we are going to publish very soon a proposal that will start to debate some elements that should be part of this treaty or in this court. I'm not going to go further into different elements. Of course, there are many others. I believe that we are going to hear also about the centrality of the rights of affected people and then the indigenous people. And we must stop this corporate capture of the process of negotiations and implementation of the treaty. So to make sure that these companies should not be seated on the negotiation table to negotiate the rules that we intend to regulate them. So this conflict of interest is obvious and should be denounced. We must fight against that to make sure that this international corporation and their representatives should not have a negative influence on the treaty. And to close, I'm going to speak of what we have been doing in the region. We have been working along the last years at the level of Africa. The most important treaty has been at the national and local level because we believe that all the struggles we have been fighting at the continent must have an essential role to define how this treaty should be enforced, what kind of provisions to make sure that we end this process with a treaty that is significant to the people that are in the front line of human rights violations. So we have been working at different levels exactly to show the corporate capture of our states which is an essential element of the impunity promoted by the current socioeconomic model. And therefore, we have been working also directly with affected um, people, civil society organizations, with unions, and recently with religious organizations as well. Therefore, our work has been conducted at several levels, and one of our tasks is to show the different lines of struggle and how the struggles at the local level should inform these processes. We believe that the peoples that are in the front line of these violations have a lot of relevance, a lot of knowledge to defend the legal instruments that we must have. And in this case, international instruments is the level that is missing to regulate transnational companies. Therefore, I'm sorry, to close, I want to highlight the importance of solidarity, the creation of spaces that have been created exactly by this kind of process. Maybe more than the struggle for the treaty itself is exactly to create these spaces of convergence that we're having here today, that we are creating and that have been created by other organizations as well. It's essential to have international solidarity for this type of process, to connect the struggles, to show that Vale's actions here in Mozambique is as criminal as it is in Brazil and Argentina, to show the way that these transnational companies work, the patterns of behavior, the ways in which they co-opt local companies, and to link different violations of human rights, the struggles of affected peoples have been one of the essential ways in which we have been advancing the struggle for this binding treaty, to bring everybody together, to bring all of this experience and this knowledge together for this controversial space of struggle, such as the UN, for example, the arena. Unfortunately, I have to leave, but I want to leave you with my contact info if you wish to and keep in touch. Thank you, everyone. Thank you, Alma, for the conversation. Thank you, Erica. Thank you, especially for the effort to be able to participate in this um, Erica cannot stay for longer. So if you have any questions, you can send it to the chat box. And also there is a Q&A session, a Q&A box. If you have any questions, you can send them. It is an invite to interact. And we are going to have also presentations. After presentations of the other speakers, we are going to have a debate moderated by Fernanda. I have some questions already for Fernanda, but I hope that she can stay with us. The next person to speak is Manja. She was with us in the 7 negotiation session. Manja is from Indigenous Peoples' Rights International. She is an Indigenous attorney in the fight for human rights with 2 decades uh, of activism. She has supported the work of the Special Rapporteur of the UN on the right of indigenous peoples, with experience in the management and coordination of programs, research, advocacy and development, and capacity building. So much, it's a pleasure to have you with us, with speaking of the importance of legally binding instruments on transnational corporations.
Thank you so much, Letitia, and it's an honor to join you today to discuss on the topic of Indigenous peoples and the legally binding instrument on transnational corporations. So I'm an Indigenous person, and I currently work with the Indigenous Peoples' Rights International, an Indigenous-led or international organization that was born out of the need for an internationally coordinated action to address the rising criminalization of and violence against Indigenous peoples worldwide that mostly happen in the context of business activities and usually done in an environment of impunity. The survival of Indigenous peoples, who are always called the guardians of the remaining biodiversity around the world, continues to be threatened by corporate activity that includes mining, drilling, construction of dams, deforestation, agribusiness, toxic pesticides, water privatization, etc. And these are always carried out on Indigenous people's land without their free, prior, and informed consent. Most often, there is no legal recourse for Indigenous peoples at the national level, more especially when the corporation involved is transnational. And most countries do not have national legislations that cover obligations and accountabilities of transnational corporations. So in the next slide, in my brief presentation, I will cover these topics: the relevance of the LBI, or the proposed binding instrument on Indigenous peoples, the updates or relevant information on the treaty negotiations in relation to Indigenous peoples, and opportunities and challenges for Indigenous peoples in the treaty negotiations. The relevance of an international treaty to regulate transnational corporations cannot really be overemphasized. It cannot be denied that Indigenous peoples worldwide suffer the worst brunt of adversities caused by business activities. We recently received information of recent violence against Indigenous Maya Kekchi in Guatemala, who are resisting the continuing operation of a nickel mine that has been operating illegally since 2015. And on November 18, the government declared a state of siege, which is similar to a martial law, which gives the military control over all police forces. It grants unbridled power to the military and suspends important fundamental rights like the freedom of expression, of movement, assembly, and more. And since the state of siege was declared, there have been 40 reported military raids targeting Indigenous leaders and communities and journalists. Women and children were not even spared, and they were subject to humiliation and sexual threats. There have been 60 arrests reported so far. Also, 2 days ago in Argentina, an Indigenous Mapuche was killed by an armed group that often opened fire against their community. Until now, it is not known whether this armed group are military, police, paramilitary, or private armed groups. In Brazil, in the first half of this month, Amnesty International reported attacks, threats, and persecutions against various Indigenous peoples. On November 16, military police of Roraima used excessive use of force against the Indigenous peoples of the Tabatinga community in the Raposa Serra do Sul. On November 1, two Indigenous Yanomami were shot by prospectors. Attacks and arsons were launched against Kiowa community in Mato Grosso do Sul. And three Indigenous women who amplified the struggle of Indigenous peoples at the COP26 in Glasgow, Scotland this month are being persecuted and denounced. Next slide. And in April this year, we also released a report entitled An Anatomy of the Practices to Silence Indigenous Peoples. And this highlighted the pattern of criminalization and harassment within the Brazilian context to silence Indigenous peoples when they act in defense of their collective rights, their lands, and their environment. The report shows how Indigenous communities have organized themselves to guarantee their own security and how they have taken strategic actions to overcome this reality. So all these cases that I mentioned, even if they happened in Latin America, resonate in many Indigenous communities around the world who face similar challenges in relation to business activities. The next slide. There are many reports, actually international, regional, national reports by different bodies like the United Nations and the Inter-American System that shows the impact of business activities is most disproportionate to Indigenous peoples. We can also refer to the Global Witness annual reports that lists Brazil on the top of the most dangerous countries for environment defenders. These are among the reasons why an international binding instrument on transnational corporations is most relevant for Indigenous peoples. How then do we assess the draft treaty and the treaty negotiations in relation to the protection of Indigenous peoples' rights? Next slide. I would say that there has been significant developments, but still there is a lot of work to be done. In the zero draft of the treaty that was released in 2018, there was absolutely no mention of Indigenous peoples' rights. Indigenous peoples were only mentioned in a couple of articles where marginalized and vulnerable groups were enumerated. So maybe when they were drafting the zero draft, they were thinking, okay, so we need to enumerate the marginalized and vulnerable groups, and we will include Indigenous peoples in the list. So what you see on the slide now are the only two articles that I mentioned, which mention Indigenous peoples. In the third draft, next slide, the third draft was discussed by the working group last month during their seventh session, and it has significantly improved since the zero draft. I will mention a couple of highlights. In the preamble, this is now a reference to the UN Declaration on the Rights of Indigenous Peoples. The disproportionate impact of business-related human rights abuses to Indigenous peoples is recognized also in the preamble, and it also mentions ILO conventions, which is very relevant to Latin America, where quite a number of countries have ratified ILO Convention 169 in relation to the rights of tribal peoples or Indigenous peoples. In Article 6 on prevention of human rights violations, it still mentions Indigenous peoples in the enumeration under meaningful consultations. But in addition to that, a paragraph was included that reads, ensuring that consultations with Indigenous peoples are undertaken in accordance with the internationally agreed standards of free, prior, and informed consent. So these are good developments so far, but as I said, there remain to be big, huge challenges for us if we wanted this international treaty to give full respect to Indigenous people's rights. We face many challenges in the days ahead in relation to the treaty, but there are also some opportunities that the treaty negotiation brings to Indigenous peoples. First, this is a historical moment to define the human rights accountability of transnational corporations. True, we have the UN Guiding Principles on Business and Human Rights. However, 10 years since its adoption, the general assessment is that these guiding principles have failed in stopping human rights violations around business operations. On the other hand, it has become more worse, especially during the time of the pandemic, where it was business as usual for extractive industries, while Indigenous peoples faced many restrictions in the exercise of their rights. The binding instrument is an opportunity for us to go beyond the guiding principles towards a binding instrument to make transnational corporations accountable. It is an opportunity to further elaborate Indigenous peoples' rights in an internationally binding instrument. This is also an opportunity for Indigenous peoples to unite their voices and struggles at the international level and highlight real-life narratives from the ground. There are also some regional and national initiatives to make corporations that are trying to make corporations accountable. For example, the European Union is currently discussing a regional legislation on mandatory human rights and environment due diligence. We can actually further engage with these intergovernmental bodies, but we should not abandon the international treaty process because most often, even the regional and the national processes fail. Next slide. We also have to prepare for, strategize, and unite on how to face these challenges. For one, there's a growing fear that the treaty process is being captured by corporations. In other words, corporations are having more influence on the states that are engaging in the treaty negotiations. In the last session, for instance, as Erica mentioned, there was even a proposal to include businesses in the negotiations. When this happens, it will be a continuing battle to shape the provisions of the proposed treaty away from the profit-centered interest of businesses. The limited participation of Indigenous peoples in the treaty process also poses a challenge towards our objective of elaborating our rights in the treaty. There have only been a handful of Indigenous organizations participating, and with the COVID-19 pandemic, this is small number even dwindled further. In the last session last month, there were only 3 Indigenous peoples in the room in Geneva, and a couple more joined virtually. So there are also few states that are negotiating or engaging, and even fewer that have progressive positions in relation to the treaty. So we need to push our governments, the progressive ones, to take part in the negotiations and later on to ratify it when it is finally approved. On the content of the treaty, it is still lacking or inadequate for Indigenous peoples. While the last draft referred to free, prior, and informed consent, it was only in the context merely of saying yes to a business activity. This is not the case because free, prior, informed consent is integral to the right of Indigenous peoples to self-determination and the right to lands, territories, and resources. And this is what we should push for in the treaty, the recognition of Indigenous peoples' ownership, control, management of their territories, and to their Indigenous political institutions. Moreover, there is inadequate protection of human rights and environment defenders in the proposed treaty and lack of provisions to cover international financial institutions. It is a long way for us, and this is a challenge for Indigenous peoples to raise their awareness about the treaty process, capacitate themselves to engage, and increase their participation. So I end this to give more time for questions. Thank you.
Muito obrigada, Manja.
Thank you, Manja. We already have questions. So I encourage you to ask questions. So our next guest is Tiana Mazo. She's part of OMA. She's working on her PhD. She's a researcher from ECOA and popular lawyer. She was in our last session. She's going to give you an overview of our last session perspectives and advancements and also challenges that we have ahead of us. And she's going to talk about the importance, she's going to keep talking about the importance of the binding treaty to be signed in an ambitious, efficient way, just like we have been fighting for, not within the UN, but outside the UN. Thank you. Good morning, good afternoon to Erica, good evening to Mancha, for all those who are participating. I'm really happy representing not only OMA, but also to be with comrades discussing. I'm going to talk about our process at OMA since 2015. We call it Human Rights and Business Agenda to state the primacy of the human rights when it comes to free trade agreements. I'm going to give you some background and then talk about our seventh session. Since the 70s, we've been discussing transnational corporations as they become more influential in politics, especially as Salvador Allende has said in 1972 at the UN, and there's G77 movement and pressure from the civil society created a first phase that David built, say, so after Allende said this, we created this committee on international investment, international corporates, that in the 90s presents the first document, which is the Code of Conduct of Transnational Corporations. Why? Because oftentimes people say that this has never been discussed, that this is something new, the direct obligations, as we have discussed in our seventh session. So we've been discussing this for a while. And then the second phase between 97 and 98 with a working group that discussed extensively the role of transnational corporations and how to monitor them, how to create a method so that we can follow on the violations by transnational corporations. And then in 2003, we had a first draft we call the standards documents on transnational corporation responsibility and other businesses. So we've been discussing terminology for a while. Then in 1999, we had the Global Compact by Kofi Annan, and then after this, we didn't have things that were as binding. And then we do it again with Professor John Booker in 2005 to create the guiding principles in 2011. Since then, we've been discussing guiding principles because they are consensual. But there's a lot of criticism from the civil society that show that the guiding principles are artificial. But they have advanced, but just like Fernanda has said, we still have to go deeper. We have to talk about the obligations again because they didn't include in the guiding principles. We need to talk about international cooperation. And now, since 2014, we've been discussing the binding treaty because then in 2013, some countries such as Ecuador, Bolivia, Venezuela, Nicaragua, Pakistan, Sri Lanka, I'm not going to remember all of the countries, but they were saying the guiding principles are not enough. We still have transnational cooperations violating the human rights. These tools is what we call soft law. So we need to go beyond. I'm not going to repeat what Adoracion has already said, but we work on Juan Hernandez, Pedro Amiro, that talks about Lex Mercator to to drive impunity. So we don't hold transnationals accountable for human rights violation, and the victims don't have a reparation. So we can say that today we have three aspects. One point is the binding treaty, and I think we still have countries to join, but it is already strong because of the resistance we have in Latin America, the resistance against the free trade agreement of the Americas. We have seen in Latin America more discussions about national action plan related to guiding principles, but in Latin America they become plans that will not build on the history of human rights. In Brazil, we discuss transnational cooperation, been doing this for over many years. And if in the human rights plane we discuss this, but this agenda, there's overlapping, but we don't recognize history. So we have a study, you can write on the chat window the name of the studies, where we have looked into many of the national action plans, and we have confirmed that they're not effective, they don't have participation. In Brazil, we have a decree about human rights in business, but this decree was built on the National Action Plan, but they didn't include the civil society, no consultation with the civil society. That's why it's so criticized. The third initiative is about due diligence, the Russian talked about. We have this in France. We have this in Germany, we have in the EU of having a due diligence law, but we also see in Brazil and in many other Latin American countries that due diligence would work for some European countries, as we see the case of Total, that shows the inefficacy of this mechanism. But in Latin America, it's even worse because of all this inequality of development when it comes to the international cooperation. The practices that we have in the Sun in the Global South is more intense.
So it's really difficult to materialize this due diligence. It's and the fact that they achieve or not results is not being considered at this point in Brazil. We have different agents of the judiciary branch saying that if the companies have a code of conduct and any type of internal organization, in a sense, we can trust that there's good faith on the part of the companies, in fact, of really monitoring if these codes of conduct are in fact implemented in Brazil, as it's the case of Ali. So in my final minutes, I want to think of our challenges. It's still a challenge to establish obligations for transnational companies, direct obligations, as we call them. In the 2017 session of the treaty, we had a panel that debated this in depth. Manuela was part of this panel. Olivier de Schutz spoke of the need to advance even further. In the opening of the 7th negotiation session, Michelle Bachelet talked about that obligation to advance in the obligations for transnational companies. And the companies themselves have the possibility to take the governments to court, as the case of Ecuador and Uruguay with Morris. It doesn't mean that we are offering the companies more guarantees. The desk rapporteur prepared the study, Andres' study, and Andres, I want to ask you to promote your book, and I want to recognize the importance of advancing towards this form of obligations. The second topic are speaking of the human rights violations themselves. Is it a violation or is it harassment? We understand it as what companies do are violations of human rights. So we don't want to remain in this field of the language of violations and impacts. You can, of risks and impacts. You can mitigate risk, but you cannot mitigate violations of human rights. That's why it's stronger. We must use a stronger language. We cannot mitigate certain kinds of impacts. There's the comment number 24 of DESC on this topic. And for me, it's very symbolic what happened in Rio Doce in Brazil, the constant attempt of the corporation saying that it's an impact, that it's a risk, can be mitigated, while what we want to discuss is mitigation and effective measures for this case. The third point is the reformulation of this concept of due diligence, that due diligence is not just a checklist that company says, well, I'm going to do this and that, but that in fact is the monitoring of effective results and not the due diligence for sustainability, in fact, to please the state shareholders, but in fact, it's monitored and it's enforced not only for the company, but for the whole supply chain. And it's very important that they take on this commitment to the results. The fourth point that I think that we can discuss, and this is a topic where the attorneys are part of this debate, as are criminal and civil liabilities. For us to recognize this asymmetry of powers between corporation and victims in the access to court, in the use of instruments, in the economic capacity that they have to file a process, file a lawsuit. In Brazil, there is a consolidated discussion on the uh, liability regardless of guilt, the necessity or not of the burden of proof. In the case of Chevron and the victims that were achieved by the operations in Ecuador, how much of financial resources we need to give continuity of a process, to access territorial obligations, to access the international system of international human rights. So we have these discussions that to think of a international court or monitoring committee. A fifth aspect with which we have been working in the seventh session, we entered the discussion article by article. So each word, each paragraph, the ability to offer arguments if this exists or does not exist in different articles. In this fifth commentary, we must think of extraterritoriality elements and mutual legal assistance, which is something we must also think deeply in the access to information, the duty of transparency. Something that is very precious is the non-forum, non-convenience to forum necessitatis, the main instrument that we use to offer access to justice. The sixth aspect would be the aspect of remediation, with the remedies. This is something that we have been working with in Roma, but in this text, in the seventh session, we also talked about this horizon of possibilities. So this 6 points are in the document of elements in the first negotiation. They were in the panels of specialists, but they were a little bit absent from our discussion. In the six negotiations, they were reproposed by some countries. This is a moment where we can rebring this, bring them back to the table and go deeper into this theoretical debate, insisting with the countries. The seventh point that has to do with the matter of negotiation is this process of corporate capture that was also brought by Manja and Erica. So the methodology of negotiation will be based on the Friends of Presidency, something that we tried to advance in Geneva. It was not clear to the party state. And in what was built, we had the possibility of consulting transnational companies about the draft. I'm about to close. We have discussed and tried to, in countries such as Egypt and Palestine, were very critical of this possibility. And has always been very dear to Homa's campaign. This question of understanding that transnational companies in this case must be accountable. If they enter in the negotiations of our rules, in the rules of the game, it will be very difficult. Article 5.3, negotiations in the work with tobacco. This already forbid tobacco companies to participate in the negotiations due to their own interests. Another initiative is this attempt to empty the agenda of the treaty, be it by due diligence or in this discussion that we had some weeks ago of the Framework Convention led by Professor Claire O'Brien. This is an attempt to create a new mechanism of soft law with this discussion of consensus, the power of consensus, but emptying this character of the mandatory enforcement of the treaty, the strength that the treaty may have in comparison to a convention. So to close, these are some of the 7 points that we think that are on the table in the end of the seventh session and what we propose to the next session, because as we don't know what is the methodology of the Friends of the Presidency, sometimes we may arrive with a text that is completely ready, but our positions are very contradictory. We have the position of the Palestine on national obligations and European countries, which have a completely different position. So we must understand how they will um, conclude, materialize this text. And in this year, the main challenge for civil societies is the positions of states and defending our positions, because the texts that are considered by the presidency are the propositions made by the state. So this was a struggle of civil society so that our contributions, the homework, producing oral interventions, so that this can be at least collected in a website of the working group. So before including this in the text, we must work with our own state for this mediation. I'm sorry if I exceeded my time, but this is what I had to bring. Thank you. Now, we have one person that raised their hand, which democratically I will allow, because this is Professor Manuela. And we have more questions in the chat. First, I want to thank all the speakers. After Chen's speech, we have to think of the challenges we have ahead of us. In the role of facilitation, this challenge of trying to stop the corporate capture. We know that there is a very strong lobby. We have been experienced this lobby from during the sessions, during the negotiation of the binding treaty, a very strong lobby to empty the content of the treaty. We know that this already exists, that this change in the process of consultation of transnational companies, cannot be admitted. How can transnational companies be consulted on a treaty that is meant to regulate them? So this is a very interesting position. I want to ask a question focus on that to Fernanda. How are we going to deal with these challenges in the scope of this friends of the presidency? But I pass the floor to Manuela, and we will also answer the questions of the chat. And I invite the speakers to read the questions in the chat box or in the Q&A box. And so you can choose the questions you want to answer to. So first, Manuela, Roland, if you wish to speak, raise your hands, otherwise we will read your questions in the Q&A box. Manuela. Thank you, Leticia. I raised my hand because I thought that the way in which I want to ask the question is important. First, I want to thank the presence of Fernanda as part of the working group on businesses and human rights, because what I see in dealing with this topic in comparison to other academic environments where this theme is present is that many people defend the guiding principles, denying the importance of the treaty. So her speech as a member of the working group on businesses and human rights, so maybe it's not clear, there is a working group on companies and human rights with the mandate to disseminate the guiding principles, but there is an intergovernment group of open composition formed by different states that negotiates the international treaty on business and human rights. So it's a mistake and an appropriation that is not made in good faith of different people on this topic, saying the treaty is not important. What's important is the guiding principle, created an opposition between both. And Fernanda brought a very clear positioning, saying that in different meetings, in different negotiations of the working group, on the importance, the undeniable importance of going beyond the guiding principles. What I want to give you as a position, with all due care, but it's important to hear from someone from the working group of what to observe in the process of negotiation. The groups that represent enterprises such as the International Association of Employers, International Chamber of Commerce, and other states that host the transnational headquarters to defend the guiding principles and the process of the national action plans in detriment of the treaty. This is not a coincidence. Probably these other instruments in detriment of the treaty, they are less challenging. They represent less restraints to the companies in terms of obligations. I want to hear from Fernanda as part of the working group. What's her point of view on this um, alleged contradiction and the position of transnational companies in that sense? We can ask the question and have the answer straight. So, Fernanda, I know that you're in Geneva. I think she's in Chile. I'm sorry. I want to thank Manuela for the comment. It's important to recognize this as well. This speech of opposition between different processes that should, from my perspective, aim at the same goal. They should add to each other and not work in opposition. So I think that the comment of the opposition between public policies that usually aim at implementing the guiding principles and the processes that are in different countries that instead of improving the human rights in their countries should also think of creating laws to implement the due diligence and the negotiations at the binding treaty at the international level. There are many actors, especially in the private sector in some states of the global north, specifically that use this speech of saying, oh, we already have some voluntary instruments, such as the guiding principles, in order not to effectively engage in an open way in the negotiations of the treaty, sometimes even blocking them. So I agree that we must be careful in order not to feed these speeches that generate this kind of conflict and confusion in some cases. They use this. At this moment, the working group is preparing a thematic document on corporate capture, interference of companies. This can be an important subsidy for the negotiation process of the treaty and interference on part of the International Association of Employers and International Chamber of Commerce. So we hope that we can advance more and more to this complementary nature of the processes and offer subsidies. We are the working group. We have this possibility of dialoguing with different stakeholders. So defending the civic space of participation of civil society, of civil rights advocates in the process of the treaty and in other processes as well. So I recognize what you say, I acknowledge what you said, Manu, and I reaffirm that there is a complementary nature in the process and that we should take all the measures so that negotiations are not blocked.
Muito obrigada, Fernanda.
Thank you,
É
Fernanda.
ótimo te ouvir, é ótimo saber
It's great to hear you
dessa tentativa, né,
and to know about this attempt
principalmente
to
fortalecer
especially
junto com as
strengthening
organizações
the binding
Tem
treaty.
perguntas no chat, eu
We have a
vou
lot of
ler
questions on
algumas
the chat
delas
window. I'm
aqui
going to
para
start with the question by Renata.
é bem interessante, né? Quais países
Very
têm
interesting. What are the
aderido
countries that have been in a line to
isso
this
muda porque
treaty negotiation? There's
muda
changes
muda
because
e as capitais mudam.
these changes in the world, and in each session we have different countries. Oma
Tem artigo
has actually written an article about how the states have positioned themselves in
muito
the
interessante porque
sixth session. This is interesting because we can see Oma has shown our position,
o que a gente espera
what we expect from the treaty, what would be effective and efficient
regulador das empresas
and regulating treaty to provide justice for the affected communities,
tocaria,
to
seria
end impunity,
racista, patriarcal.
and
Estados
the positioning by the states and compared to ours. And some states are aligned in some points, as we have
panelistas, né?
mentioned earlier. What are the our fundamental points?
Vai mudando, né?
But
Então,
this
eu vou.
changes.
A Tiana já se apontou para fazer
Sienna
essa
wants
pergunta. Eu vou passar a
to
palavra
talk to this question, so I'll turn it over to her.
Tiana, por favor, conta pra gente
Sienna,
como é que foi
over to you.
depois
Please tell us
há mês atrás, como é que foi a sessão
how the session, the seventh session was in terms of allied states. Thank you for the questions. I think Palestine defended our positions. Cameroon also defended our positions. And then the other countries, they'll change. Of course, not everybody is 100% adherent to our proposals. But Egypt, Namibia, Cuba, South Africa plays an important role still. I think Panama too was really active defending gender. I think countries that in the past didn't had more complicated stances, like Mexico, they are more open now. They're not standing behind so much as the guiding principles. Peru too. I think I would highlight these. Brazil. You asked about Brazil. Brazil abstained in the voting for this resolution. I'm not saying that Brazil has defended good points in this negotiation, but I can say that Brazil has improved their position in this space. So Brazil didn't make any comments on gender, as usually they would challenge gender, the gender agenda. Whenever the civil right would make an intervention, Brazil would ask for a response. So Brazil was more silent, but of course Brazil, because of the history that we have, we could have played more of a leading role in this discussion, but this hasn't happened. I want to answer two more questions that I see here on the chat window because they're related to what I said about the documents from the 90s and the 80s. That these documents didn't move along, not neither the standards nor the code of conduct have been negotiated. This is common in the international system that you replace an agenda with another agenda. So discussion that came after the Global Compact has replaced this discussion. If you think of Development Convention from 1986 was replaced with other agendas like SDGs and other agendas that replaced this. So the agenda or the discussion with the treaty is replacing the discussion from the 80s and the 90s. The difference between abuse and violation of human rights, what we understand is companies, the transnational corporations don't sign the human rights treaties, so they can't They can't be held accountable for human rights violations, so they can abuse them. So what we discussed that abuse is softer than violations. If you say human rights violations, what comes to mind is the idea of holding someone accountable. If you say abuse, I mean, you have to verify if it was an abuse. You have to quantify the abuse if it was too much or too little. So you are connecting the idea of mitigating risks, mitigating impacts. So that's why you have you see that people use abuse and some people use violation. Behind this is the discussion that, okay, if you have direct obligations for the corporations recognizing they violated human rights, you are giving power to the international corporations in the international law. This is a discussion. Olivier Schultz, Manu also has many articles about it, so we can go deeper into the discussion. But in practice, I would say that in real life, the communities, they understand that their rights were violated and not abused.
Obrigada, Tchena.
Thank you, Chena.
Eu estou identificando
I don't really see any more questions that haven't been answered, but I understand that Manja or Fernanda, Erica had to leave, right?
já temos uma mão levantada.
But someone have has their hand up. But I just want to add something to Tina's response because uh, in our fifth session, at the end of the session, I remember that we were actually wrapping it up. Brazil, Brazil's the delegation proposed that the discussions should be closed discussion, that the civil society could not participate in discussions anymore. We this was denied, this was turned down, especially by Egypt. So we have states that defend, that value the position of civil society, and that feed on our positioning to have their positioning. And this is what guarantees changing the treaty text. Because for those who don't know the dynamics of negotiations, the states talk, and then the civil society will talk. So the possibility of lobbying with the states is basically before that. Of course, it is just a consultation for the next session, but this is how we can interact and manifest ourselves to change the text. About the Palestine, when we had the proposal that was accepted by the chair by Ecuador, the proposal from the UE to have transnational corporations to be consulted in the process of negotiation, the Palestine said with all the words that this means a conflict of interest, a corporate takeover of the space, and once more, they valued our participation as civil society in the space of negotiations. So yes, we do have states that want to go against this proposal, this treaty, defending the guiding principles, voiding our proposal, taking a step back. We also have the EU that basically calls for the participation of transnational corporations to be consulted. We also have states there that defend us and value our participation. So I turn it over to Andressa and I invite our comrades to ask more questions, to make more comments, to raise your hand, to participate. Andressa? Good morning, everybody. I just wanted to say two things. I'm gonna ask a question to Manja, but I wanna just add to what Jenna has said about abuse and violation. Is that we have to understand that this nomenclature was consolidated in the framework of human rights and business around guiding principles. This consensus, as they say, was a consensus that civil society didn't participate of, and many states didn't agree with. But they say it's a consensus. But this is not part of international law nomenclature. I mean, they don't make this difference. They talk about violation. They talk about violation by third parties and by private people. Of course, the obligation when it comes to human rights by the state and by the private sector are different. The state has the obligation of promoting human rights, so it could be held accountable by the violation by third parties, but that does not mean that third parties don't have the obligation in terms of human rights and they don't violate human rights. You have to be careful because these differences in terms of words and concepts, sometimes it's a strategy that people use to take to change the direction of the discussion. So there's an interest of stepping away from the discussion of human rights in international law, and they keep talking about compliance. They keep talking about corporate responsibility (ESG) and these projects of self-monitoring and due diligence, as we see. So we defend that the discussion should be brought back to international law of human rights because only in this camp and with this wording we can have the right accountability. That's why we are repetitive sometimes when we say that we should say violation, but it's not only about a vocabulary or lexicon. There's a strategy, a semantic strategy behind this that we should reinforce. My question to Manja is when it comes to academia or activist academia working with social movements, how can we? I mean, you mentioned the difficulty articulating with indigenous groups around the treaty, but this is something that you've been trying to do. How can we help from the academia democratizing the access by these communities to materials about the treaty and our content? For example, we have this notebook that Leticia said with all the information about the treaty that we put together, especially Friends of the Earth. But how can we get this to the indigenous communities so that we can somehow give you support in in working around the treaty, which is very important, as you said? This is a question to Manja.
Okay, so thank you, Andresa, for that question. And indeed, the academe can contribute a lot, actually, a source of evidence, a source of information for indigenous peoples. Especially, you said that there are researches, if there are tools, if there are capacity building modules, if there is a way to conduct capacity building and awareness raising for indigenous communities and organizations, that would be a great help, actually, that the academy can contribute, not just actually on for indigenous peoples in raising their awareness and their capacities to negotiate, but also research or information for non-indigenous to clarify the rights of indigenous peoples, because it's usually misunderstood. For instance, there is a position of free, prior, and informed consent for everyone, but under international law, free, prior, informed consent is still attributable to indigenous peoples. And if we attribute this to just anyone, it will dilute the rights of indigenous peoples to self-determination under the land, territories, and resources, because it is under this right that the free, prior, informed consent comes in. Also, there is this usual mistake of lumping together indigenous peoples and local communities, which is also dangerous and which is also disadvantageous to indigenous peoples, because under international law, local communities does not really have any definition. What does it mean? It can be a local community in a city, a local community in the countryside. It does not have a definition. So if we want to refer to indigenous peoples, we refer to them as such. If we want to refer to peasants, we refer to peasants, or to other minorities, we mention them by names. But to lump them together with local communities just confuse and might even dilute the efficacy of the treaty or the provisions. So these are actually matters that need academic research and academic debate argumentation to support why the indigenous peoples are taking the position that their FPIC should not be lumped together with others, and also local communities should not be lumped together with indigenous peoples so as not to dilute the rights of indigenous peoples. That's one thing actually that academe can support indigenous peoples with. And also in the trainings and awareness raising materials that was mentioned earlier, it is best to translate this into indigenous languages because it is there. It would be more understandable for them, and it would be much easier for them to comprehend and understand. There are many indigenous peoples organizations that the academy can work with. In Brazil, for instance, we have the APIB, the Articulation on Indigenous Peoples something. It's it's a Portuguese term, so I don't know, but it's the APIB. I'm sure that you have encountered them. We work with Sonia Guajajara and the other indigenous leaders in Brazil. Also there are regional organizations of indigenous peoples in Latin America, uh, the Koika, the Kawi. So these are organizations that we can actually that you can actually work with to reach the indigenous peoples in their communities in the different countries. Thank you.
Estava colocando o site da PIB, para quem não
I
conhece.
was putting up the APIB official website for you to get to know, especially for those who are not from Brazil. I just put it on the chat window. Humberto wants to ask.
Essa pergunta, ou também
We can have our comrades talk to this question. It's by Marcelo. Are there studies about the influence of international treaties within the national states that have signed these treaties? I don't know if anyone wants to talk to this question, make an analysis. I don't know.
talvez a Chena ou a Manu.
Maybe Chena, Manu.
Manuela gostaria de comentar, é bem a
I think
linha.
Manuela
Por
could
favor.
talk to this question because this is what she researches.
Ó, eu não estou na mesa, né?
I'm not part of the panel,
Eu acho assim que
but
sempre que coloca essa
whenever this
tentada
question comes up
essa relação entre o
about the relation between
nacional
national,
como se fosse
international,
um certo obstáculo, né?
as an
Porque fala que
obstacle because the treaty is international and then have the challenge of being ratified nationally. Brazil doesn't comply with the national treaties. I mean,
essa visão que se faz, né?
maybe this is the
Eu acho que tem
discussion.
alguns aspectos, né?
There's some aspects. Number one,
Negociação, né? Então não
we are
tem
negotiating the treaty,
acho que total de
so we still
realmente
don't know the capacity of this treaty that's not ready yet and how it complies with national laws. The diagnosis we have so far is the national action plans are not effective, guiding principles are not effective. We have this diagnostic. But now we're fighting for improvement of this legal framework to give agency to people to bridge these gaps. And this is the international treaty.
a questão que eu acho que a gente deve observar
But
é que
I
assim,
think
o que mais me move,
that
mas uma das coisas que
I
realmente
mean,
fui prestar nisso
what
tudo
moves me
é
to be part of this process is the resistance
empresas e dos
by
trabalhadores das
corporation representatives and the states
se eles estudam
where these corporations have headquarters against the treaty. Because if the treaty didn't provide any change
direitos humanos acabam vendo
to human rights,
não haveria tanta resistência.
there wouldn't be so much resistance. We have concrete boycott every day to this process. Because after this treaty, as Joaquin said, the law it doesn't create law, but the national societies have to create a space of representation to give agency to this process. We're doing this in Brazil. That we have the parliamentary discussion, and we have to have dialogue because we want Brazil to be more open to the future treaty, which has to be good in representing the the rights of the companies. They're going to be defended as abiding treaties. So we need to have a good treaty when it comes to human rights in business.
Thank you, Manuela. We have a last question in the chat, and we are heading to the end of the panel. It's a question from Ximena, and I think that Mandia could answer because she has field experience, let's say. What should we do so that Indigenous peoples have voice and that they are heard in terms of their rights? We know that most of the times they're simply ignored. So I think that Manja has been working in this front. And from this perspective, I invite Manja to answer to this last question. And then we close this opening panel. Thank you.
Thank you, Leticia. There's a lot that can be done actually to support Indigenous peoples to be so that their voices will be heard. For instance, how do we support their positions, or how do we bring their positions into the international arena, or even the national in the national level, even in the media? How do we help in amplifying their voices through the different media, through the national, international media that we use? Are we conscious of including them in our discussions? Are we conscious of including their issues when we debate or when we enter into negotiations or elaborations of many issues that impact on them? Also, how do we contribute as well in the capacity building and in awareness raising? We have very strong Indigenous leaders who have very strong voices, but as you said, their voices are usually kept on the are usually muffled or are usually limited on on the ground in their communities, because media is not picking up on this on their stories. Academe are not it's not always a very sexy issue for academe to cover this as research projects. And for other organizations, they are more focused on issues in many other issues or many other causes other than Indigenous peoples, and sometimes even separating environment from Indigenous peoples. So these are matters that we can actually do, how we can strengthen solidarity and cooperation between Indigenous and non-Indigenous groups, whether academe, or whether media, whether civil society, so that we can amplify the voices of Indigenous peoples from the ground.
Thank you, Manja. It's essential to have your voice here in this agenda and your contribution on how we should struggle. So closing this panel, I want to thank all the speakers for their important contribution. As a last reflection that remained to me and was an analysis that we made after negotiation session, is that the last document that we have in hands now, it's a field battle of juridical arguments. So we have the possibility from now on to continue in this dispute, because several elements came back to the negotiation table. As we said today, obligations of the transnational companies, the scope of the treaty, the priority of human rights, prevalence of human rights on the free trade agreements. So several points that had been lost in 2007, since 2017, since old drafts, they came back to the table. We resumed their discussion. So it's important for us to position ourselves to create mobilization and that we continue in the struggle. We know that in this dispute, it's absolutely important to strengthen this document. As Manuela said, it touches on the point why the businesses refuse this document. This is an impact on their position. So speaking of this point, I want to say that if we know that we are all impacted by transnational companies, we know that there's a resistance everywhere around the world. So to articulate, to globalize the struggle, this hope is an essential part of the process. And it's very good to have different civil society sectors articulated and mobilized for the struggle and to strengthen this process, not only within the UN, but also outside, and to continue to struggle in different parts of the world to articulate this network of resistance. We had an extraordinary panel, or the opening. I want to invite all the brothers and sisters that were here today. We had more than 100 people participated today at 6 p.m. For those who were registered and were selected. You're going to have a workshop on popular advocacy and autonomy of the peoples. And tomorrow at 10 a.m., we continue with a panel with André de Carvalho Ramos, Guanderson Sarreta, and several other speakers that will bring very interesting debates to this agenda of human rights and businesses. Thank you. And we'll continue our struggle within and without the academy. Thank you for the participants. I want to thank the audience and the interpreters once again that always have an important work, very generous work. So we'll see each other in the workshop and tomorrow in the continuation of the event. Thank you. Thank you, Manja. Thank you, Fernanda, Chana, Leticia, and Erica that has already left. Thank you. Thank you,
Thank you.
everyone. It was a
Thank you.
pleasure.
Um abraço.